come to Article 14. Because the first question is there a fundamental right, my lords, for persons in same-sex relations to marry, my lords, either flowing from Article 14, 15, or 21?
Mr. Dwivedi, apropos a discussion which we were conducting between the three of us and my learned sister, does anyone have a fundamental right to marry?
But since certain judgments
Forget the issue of same sex.
Yes.
Does anyone have a fundamental right to marry? Or is there no fundamental right to marry at all, according to you? Because your submission is that no one has a fundamental right to marry. Or is it, what is your answer to this?
My submission is simply this, my lord, that so far as heterosexual
No, we are not on heterosexual.
That's right. Keep
Yeah,
it.
we see that's what actually
of marriage.
triggered this idea.
Yeah.
Yes.
Does any citizen of this country for whom this court and our society and our polity has placed the individual at that highest pinnacle, and we have gone ahead and carved out, or rather discovered, so many rights: the right to personhood, the right of choice, the right of being left alone, the right of
Autonomy.
privacy, autonomy, which is at the core of personhood,
And dignity above all.
dignity, which is part of our preambular promise.
Yes.
Now, with all this, what is the question? The core question is, does a citizen or a person have a right to marry? Is it part of 21 or it is not part of 21? Granted that, but that in that sense, there is no unqualified right. We have to start with the premise that there is no unqualified right. The right to free speech is not unqualified. The right to association is not unqualified. Personal liberties are not unqualified.
Right to life itself is not
Right to life
qualified.
is not
Can be
unqualified.
taken away on
Therefore, we
convictions.
don't start with there is no unqualified right. There is no absolute right. If we start with that premise, what is the right? Does the right to life have that concomitant of the right to marry? So do not start the debate with whether same-sex people have the right to marry. Rather, what is the right to marry? Is there a right to marry?
So my submission is that the heterosexual couples have a right to marry in accordance with their custom, personal law, and religion. And that has been continuing. That's the foundation of their right. Now that right has been.
So, but therefore you concede the fact that therefore there is a right to marry under the Constitution.
Sure.
But that right to marry is confined only to heterosexual persons, according to you. Or is it your argument that there is no right to marry at all as a fundamental right?
I'm saying there is a right to marry which is founded on customs, personal law, and religion. The enactments
In that case,
passed,
as you taking the same argument further,
yes,
custom, culture, religion. Rewind 50 years ago, intercaste marriages were not permitted. Even go back further, Sapinda marriages were not permitted, right?
So there-
Interfaith marriages were unheard of,
yes.
right? So all this, the content of marriage has changed. Therefore, what was that fundamental right to marriage in
So
1954?
these
Or
change-
core content.
What is the core
these
content of the
changes
definition?
therefore have been brought about by legislation, and legislature can certainly alter the customs, and now the ghost of Larasu has been.
Keeping aside for a moment the legislative aspect, as you said, it's the culture, it's
Yes.
the customs that has brought about this whole matrimonial setup. Keeping that legislation aside, would you say that you're referring to the relevant articles of the Constitution? Is it that it is based and founded in the Constitution, the right to marry? Is the question.
So the Constitution only gives a fundamental right to form relations, associations, which is there in 19(1)(c), which can be regulated.
Persons.
Now, what we call our association as marriage has ultimately, over the course of years, resulted in a social institution. It's not an overnight something happening, and two people coming together and call it marriage. So it's a long period of time where this institution of marriage has emerged, and as a result of society's evolution.
So even prior to the Constitution,
Yes,
there was this whole customs, ceremonies,
absolutely.
and all of it.
Yes.
Once the Constitution came in, is it your argument that the marriage was...
So that right to
Correct.
marriage, which was existing as a part of social institution, will be accommodated in the right to associate in a particular manner and in a particular social institution. Asking to open the doors of this social institution of marriage as existing for them. And that's the plea, that we stand at par for various reasons and therefore make the amendments in the SMA. SMA has now become unconstitutional, violative of Article 14. It may not have been violative of Article 14 in 1954-56 when a cluster of laws were codified.
By the same token, Mr. Dwivedi, Constitution has not granted anything. Go by the theory of the dissent in the habeas corpus, or even by what is generally accepted. It only recognizes and guarantees. Nothing is granted. We are free citizens. We have taken this onto ourselves. So the right to speak, the right to associate, everything is part of our inherent rights.
That's right.
Constitution,
Yes.
therefore, does not grant.
It-
So even the legislations have only recognized. So that right to marry is inherent. If we say the right to marry is inherent, it is part of the Constitution. You may locate it in 19, you may locate it in 21, perhaps appropriately 21. Because 19(1)(c), the history you see brought was in terms of association, as we understand.
So it doesn't matter where
Yes.
where it is located or taking together it is located somewhere along with the preamble.
As we normally define a natural right.
That's right.
But the right to marriage in the sense in which
This is the problem. The moment we qualified with in the sense, because
That's
when
important.
you bring in the tradition, now the Constitution itself is a tradition breaker. The Constitution is a tradition breaker because for the first time you brought in 14. If so,
so
let me
I
just
appreciate.
complete. If you brought in 14, if you brought in 19, 15, and most importantly 17, those traditions are broken.
It can be broken.
No. Therefore, just allow me to continue with that thread for half a minute. If those traditions are broken, what is held hallowed in our society in terms of caste? We made a conscious break and said that we don't want it. We have even gone to the extent of encapsulating let's say, outlawing untouchability in the Constitution. I don't think there is any constitution in the world which says this shall be an offense as a part of its fundamental right. Therefore, traditions are there to the extent they are there. To the extent they have created the tradition, the institution of marriage, they are there. But at the same time, let us also be alive to the fact that the concept of marriage has evolved, which you yourself said.
No difficulty, Millers. Everything, a lot of evolutions have taken place. Other side has also adverted to them. We have also, Millard, adverted. The point is, all these reforms which have happened are reforms, Millard, which are made by the legislatures in the interest of women and children. And they do not alter, Millard, the fundamental aspect, the core aspect of the social institution of marriage as it exists, namely that it is an institution, it's a marriage, rather Millard, Hindu marriage, they regard it as a sanskar. So, as a sacrament, the fact that now divorce has come in, or Millard, the fact that some other modifications have.
Yes, you're right. That is
So-
by and large, but
So, but
even Hindu-
each and every reform, Millard, kindly see 1937.
we are looking at what we understand as the traditional, but there are large parts of society. It's a very diverse Hindu society. That diverse society even today, and that's why you have Section 29 of the Hindu Marriage Act. You have customary divorce, which is preserved. Therefore, divorce existed in many communities.
Yes,
The diversity is there. That diversity we cannot.
correct. So, therefore, Millard, what I submit is that the core aspect, what is the core aspect of that marriage?
That is the
You may provide for maintenance, you may have alimonies, you may have divorce on certain grounds, you may provide that there will be intercaste marriages, but ultimately the marriages remained heterosexual marriages. And number two,
Mr. Dwivedi, there are certain, to state at the extreme that there is no fundamental right to marry under the Constitution would be far-fetched. what are the core incidents of marriage? If you look at the core incidents of marriage or the core elements of marriage, not the incidents, I made a mistake. What are the core,
element.
what is the core content of
marriage.
marriage? Or what are the constituent elements of marriage?
Lord-
Just one second. If you look at each of these constituent elements, each of them is protected by constitutional values. I'm not saying 21 necessarily, but constitutional values. The
Yes.
preambular values read with 14 and 21. 1. Marriage itself postulates the right to cohabit, right? Of two individuals to cohabit together. 2. Marriage accompanies with it the notion of a family, the existence of a family unit, because the two people who come together in a marriage constitute family. Again, something which directly owes its existence or recognition to the constitutional values. 3. To bolster your submission, we must take that into account also. Marriage has procreation as a very important ingredient of marriage. Though equally we must be cognizant of the fact that the validity or the legality or the social acceptability of marriage is not conditional only on procreation, for the reason that people may not want to have children. People may not be in a position, have the ability to have children, or they may get married at an age when they cannot have children. But we therefore take your point that procreation is a significant facet of marriage. There's no denying the fact, subject to these caveats. 4, marriage in a significant way is exclusionary of all others. Two people who come together in a marriage or want to cohabit together are entitled to exclude everybody else from that area of marriage. No third member of society can say that, well, I want to share in the same relationship which you have with one of you in the marriage. It's exclusionary of others. And 5, which is equally important, just I gave you that thing about procreation, which is social acceptance of the existence of marriage. And social acceptance is then not just confined to that individual, but to the how society itself looks at that institution. Now, having said that, there cannot be any denial of the fact that the state has a legitimate interest in regulating marriage. Undoubtedly. Therefore, the state that's how the state regulates the forms in which you can enter into marriage. The state regulates how many people you can enter into a marriage when you have a subsisting marriage. The laws against bigamy, for instance. The state has a variety of other interests so that it regulates various facets of marriage. But we must therefore accept as a basic proposition that marriage itself is something which is entitled to constitutional protection, and it is not just a matter of statutory recognition.
No,
Once we cross that threshold, then we enter into the next level, which is the contested issue here. Is heterosexuality an intrinsic or core constituent element of the institution of marriage? Your submission is that as marriage has evolved, and even today, whether heterosexuality has social acceptance or not, is one thing which regulates the state's interest, because the state has a legitimate interest in regulating in marriage, and therefore it may say that I'll not recognize anything beyond a heterosexual relationship for the purposes of marriage. That's your contention.
no. So may I respond on this?
I just want to add something. Actually,
Yes.
the Chief Justice has, I had written something and the Chief Justice has virtually echoed the same thing, but I put it slightly differently.
Yes, ma'am.
I'll just read it out. What is the content? After all, what is a marriage to each other? One is to society. What a marriage to each other, each spouse, they decide what that marriage means to them. So what is the content of a marriage is defined voluntarily by the parties. That is the spouses. They decide, number one, whether to have and raise children, the procreation part. It is entirely their choice. Of course, there are social pressures. We are all aware of it. But ultimately, at the core of it, whether I will have child or both of us will have children or not is our autonomous decision. There may be marriages where parties may not live together. There is no cohabitation in that sense. Both are working. They may be meeting each other once or twice or 5 times or 6 times as they choose. So the concept of cohabitation. There may be no matrimonial home in the traditional sense. Marriages may not have any element or varying degrees of physical or sexual relationship. Now, therefore, as to what is the content, context, or cultural central to a marriage depends ultimately upon the participating, spouses. Is that right?
No, no, no. With great respect, no.
So you mean to say that if people...
This.
No,
This
please,
thought.
please, I'm looking at the voluntary part. I'm not looking at the...
Yes,
this-
I appreciate it. I appreciate what falls from my Lord. But that's the great debate which has been going on ever since the time of Kant and Hegel, my lords. Kant said, this is pure
And
contract.
keep the heterosexual element outside. We are not on that at all right now.
No, that's very fundamental. We can't leave it aside.
No. We are not saying that that is not relevant. We are saying we are testing the core proposition in regard to the content of a marriage.
Because one view is globally prevailing that some say that marriage is simply a contract. It's up to the parties to define, my lord, what marriage is. Marriage becomes a fluid concept completely, my lords, and that's one concept. And that, my lord, what are the consequences of this, my lord? I'll show to your lordship, my lord, by when I read the Nussbaum's article, my lord. She goes up to saying that then you will even have to knock down the prohibited degrees. She says that the state will have to provide justification in the court, my lord, why these prohibited degrees, my lord, cannot be. The health aspect, etc., has been knocked down scientifically. So therefore, knock down prohibited degrees. She even goes to the extent of saying there are 2 pages I'll like to read. Then they can, why not brother and sister can marry?
But that is not, that doesn't pose a constitutional problem to us because that's not.
No,
what you
no,
just a second. There you recognize the legitimate interest to the state to regulate. Now, what we are trying
where
to
do we stop? Legitimate, because state has to come and justify why we are banning the prohibiting marriage between brothers and sisters.
Of course.
Mr. Dwivedi, it's not as absurd as that, with due respect, because I think, in all societies, barring a few, these prohibited degrees of relationship exist in some manner or the other. Age restrictions exist.
So, again, we go back to the history, etc., and then see, my lord, that in Muslims it's a different.
Something even more
Hindus, it's
fundamental.
different.
There's something more fundamental. Apart from blood relationship, there is marriage relationship. For instance, sisters-in-law, brothers-in-law. Why is that relationship? Why is that prohibited? There is perhaps a very deep-rooted, public interest in that.
Of course, there is.
That is of some kind of order.
Yes.
Orderliness. So all these are legitimate state.
But therefore, the state has a legitimate interest to find out, Lord, what is that order, Lord, which is to prevail in the society, given society.
Mr. Dwivedi, that is not being questioned.
So I'm saying that if you treat this marriage as a fluid concept, which individuals in the 2 spouses are to define for themselves what it is, we don't need any law, etc. Then each couple will be deciding, Lord, what marriage has meaning
Sorry,
for them.
I didn't mean that no law. I said there is a law. There is a law. I'm talking even of heterosexual. Nobody is compelled to have children. Nobody is compelled to live together.
Lords, that's the greatest of difference, I say. It is one thing that some couples, heterosexual couples, may decide not to produce. Some couples may marry and may want to, but they are unable to produce because of infertility, of medical reasons,
You just
biological reasons.
go
That
outside the precincts of this building and some of these complexes. You see construction workers, you see migrants who are away from their houses most part of the year. They go back barely for 15, 20 days. What is that family life? What is cohabitation for them?
So we are on the aspect of marriage. Family life will vary from case to case,
Exactly.
but marriage will not. With great respect, my lord, marriage cannot be made so fluid, my lords, so undefined. Marriage has the core purpose, as I was submitting, my lord, when your lordship put this query to me, is to bring about a unity of man and woman, my lord, for a social purpose. Because society needs to perpetuate itself, the race needs to perpetuate itself. Some may not produce, some may be infertile. These don't decide. The generality is that our population has grown from 44 crores, my lord, to 1.4 billion today, my lord, it's not because of certain people, some who did not decide to produce or were unable. We have reached here because, in generality, people want to come together, they want to cohabit, they want to, my lord, engage in sex, not merely for pleasure, not merely, my lord, for taking care of each other, but for building a family of their own, something out of their own body and flesh. It's all right, some people can adopt. These are exceptions. But the real thing is that we all want our own child and we try for it. We want it. That's how the family is built up. That's how the family, the child who comes into being, we builds the relation, my lord, with the relatives. So our concept is different. Take any religion.
Mr. Dwight, if you therefore formulate and articulate the core content of a marriage, how would you do that?
Core content is the coming together of a man and a woman as commanded, as even Bible says, when Adam and Eve were there, that they blessed them for happiness and say, go be fruitful and multiply.
So therefore,
Every religion says procreation, my lord,
definition is that procreation is the definition of marriage.
this society cannot survive. And so look at the problem faced by China and Japan, and today it is being said, my lord, by statistically that world is facing the problem of aging. We can't have IVF, my lord, and adoption. So in fact, adoption, what is adoption, my lord? Some heterosexual union has produced some children, my lord, maybe an orphan, and you adopt. What is IVF, my lord, and surrogacy? It's coming together of an egg and a sperm, my lord, together to produce a zygote. So ultimately, your family, your efforts to wanting to build something is dependent upon a heterosexual union. That's the fundamental truth. That's the most essential law of nature. That's the cosmic unity. And the society, my lord, cannot survive. Nations cannot be. What is national integrity, my lord, if this society grows old and there are no children? So producing children, bearing and rearing children. Bearing and rearing children. We don't want to go to the America way. Maybe there are, again, point out some families here, my lord, who are impressed by that and where children leave the families at a young age and they are on their own. So everything is not beautiful there, my lord. And I have a very strong criticism of Justice Kennedy's judgment, Justice Sachs' judgment, and Nussbaum, Professor Nussbaum. They treat marriage as a pure and simple contract, my lord. It's not a pure and simple contract. It's the most sacred phenomena, my lord, on earth, and not confined to human beings, my lord, but to other species, plants, and so on.
When you talk of right to marriage, which is what you were referring to, so marriage in any case transcends the constitution. It is not looking for its sanctity within the framework of a constitution, having predated it by several decades, years, centuries. So when you...
And as your lordship said, my lord, that the constitution enables the legislature to regulate. Over the course of years, we find development of society, my lord, we find certain things which were good at one point of time are no more good. We today want equality within the family. So that's one more change. Bigamy again is a protection. These are all laws which are protected under Article 15.3. 15.1 doesn't affect it. 15.3 commands the state to make special provisions for women and children. Bigamy is to protect women. Maintenance is to protect them. Alimony is to protect them. So therefore, all these laws which are being made, our rights are not, the heterosexual marriages don't depend upon this. No constitution can take it away. That, I will put it like that. It's a natural right.
That's right.
By virtue of our being human beings. To deny that right means to let the nation die. That's the importance of this. And that's what Chief Justice Roberts in his dissenting judgments emphasized. And Justice Sachs in his judgment in Fori says, my lord, that this is not the essential characteristic of marriage. That's how the underpinning, two underpinnings. It's a pure, simple contract dependent upon two individuals, and secondly, my lord, it's not essential characteristic. I am therefore addressing your lordships not to follow the path of Obergefell and Fori, my lords. The path, they make a declaration. One was, my lord, to insert it. We have already made a submission, my lord, that SMA, my lord, you can't, it's not possible to insert by altering. And the other is not to, my lord, the other course of action would be, my lord, that, all right, make a declaration that they are entitled to marriage at par with heterosexuals, and therefore, and leave it to the parliament. That was one plea by Mr. Vishwanathan. So I am dissuading your lordships, my lords, from making any declaration in that context. Because those two judgments of one is majority, one is unanimous, both are fallacious. Their underpinnings are completely wrong. In India, we don't treat marriage, my lord, as a simple, pure, and merely because there is a consent. Even, my lord, I have annexed in the recent compilation, Faizi's, my lord, Muslim law. He was an ambassador to Egypt from 48 to 52, and then vice chancellor of the Jawaharlal of the Jammu and Kashmir University. And he has written, my lord, that it's not, even there, this concept that it is pure contract is incorrect. You need a Qazi, my lord, presence. You need to recite verses of Quran, and therefore, so it's a mix. Something like seniority come merit and merit come seniority. My lord, in Hindus, it is sacrament plus contract because some consent is obviously implied. If that is to be treated as contract. And that is where, my lord, Hegel comes in, and Hegel says, criticizes very sharply and says it is shameful for Kant to say that it is a pure contract. And he applies the principles of contract and says that contract involves parting and exchange of externalities. When marriage happens, Lord, there is no exchange of externalities, no promise and acceptance in the sense of Indian Contract Act. So yes, consent is there. Both couples agree. If that is said to be a contractual element, yes. But it's not a contract in that sense. And the two judgments treat it as a contract. These are essential things. Why we treat it as a contract? Why the religions, all religions, even though they are in conflict with each other on so many things, yet all of them regard not the homosexual relation as a sin. Your lordships have declared it to be not a crime. But what about that, lords?
But the moment you say that it is not just a matter of mere contract, but there's an element of a sacrament, which is again a fundamental precept of our law, at least insofar as Hindu marriages are concerned.
The fundamental precept of custom and
undoubtedly
religion.
That a marriage is not a, I mean, that's the first thing which you learn when you learn the sense of Hindu law.
Yes.
That marriage is not merely a matter of contract, it's a matter of a sacrament.
Sacrament.
Once you accept the fact that it's not a matter of a pure contract, but it's a matter of a sacrament, then it's a sacrament which is also impressed with a constitutional character.
So I have no issues. Your lordship may find it located somewhere, but it doesn't depend on that. Your lordship may find its continuance there. What was existing up till 1950, by the coming of the Constitution, is not transformed into something which is by virtue of the Constitution.
That can be said of anything else.
Yes.
Everything else.
Absolutely.
You see,
It's not that we didn't exist as a society and the Constitution switched us on. No.
And that's the basis on which we overruled ADM Jabalpur when we dealt with ADM Jabalpur in Puttaswamy. We said that the fundamental fallacy of ADM Jabalpur was that if Article 21 is suspended during the period of an emergency, that does not suspend your right to life. Because your right to life does not owe its existence to the Constitution. It's a recognition by the Constitution. Therefore, the power to suspend 21 will not suspend your right to life.
I have
That was the whole basis.
I have no problem because
Right. Now, therefore, once you say that, well, marriage is a sacrament, then you have to accept that marriage as a sacrament traces its origin to 25, therefore.
because my submission doesn't turn on this acceptance. Your Lordship may locate it. I have no issues.
Right.
Your Lordship may treat it as part of life itself. I mean, if that is so fundamental, the right to life and personal liberty, so right to life itself will be marriage.
There is a fundamental right to marry within the meaning of the Constitution.
So right to life
So
itself
we
is
are
marriage.
only joining issue with you that there is no fundamental right to marry.
No, I
You
never.
began by saying that there is no fundamental
No,
right to marry, which is really
thrust,
constitutionally
I'm sorry,
involved.
because my thrust is been that there is no equality. Don't make a declaration that the marriage which is to be
So what
declared.
in other words, in terms of constitutional, let's say, precept, there is a right to marry. In the sense that it is, that can be confined to heterosexual. But there is no marriage outside of that. There is no right to marry outside of that. So there
In
is
that
no-
sense,
and then
they
in
may,
that sense, everything else
it
follows.
is up to the parliament. If the parliament
That's-
wants to create artificial definitions and declare it,
So
fine.
there, for instance, there was no prohibition of bigamy in
Yes.
Hindu marriage. So it was brought
Came
in.
in 56 for the first time.
For that marriage matter, there was no concept of divorce. As you say, sacrament, it is still sacrament, and yet there is divorce. Correct? It is still a sacrament among Catholics even now. And yet, if they want any one of them, they go into that and get divorced. So Parliament has that, overriding whatever
That's right.
authority.
They
to the
can
extent of-
define marriage, redefine marriage, or create a separate law.
Exactly.
Define their relationship, my lord, in some different manner as
There is no quarrel-
many other countries
There's
have
no
done.
quarrel about that.
That's true.
It's ultimately in that, if it has to be, ultimately Parliament may have to do.
Out of 195 countries, only 44 countries have recognized the same sex. Maybe less.
And Mr.
34.
Dwivedi, then it leads us to one other issue, which is that assuming that you are right for a moment, that it is open to the state in the exercise of its legitimate interest, either to recognize a broader notion of marriage which goes beyond heterosexuality, or to confine it to heterosexuality. That the state has a legitimate interest in saying that we will define marriage in such a way as would promote vital societal interests, including social acceptability or the stability of the social order. Equally, even if you were to concede that, there may be an alternative formulation. And that alternative formulation would be that apart from the element of heterosexuality, there may be other elements of that associational relationship which to a certain extent must find protection within our law, even if it were to be short of marriage, even if you were to accept your point. Ultimately,
What recognition, my lord, if your lordships are contemplating some sort of recognition from the state to that relationship is essential in order to protect, my lord, afford protection to their relationship of love and affection, etc., family or adoptions or some other civil benefits. It's ultimately up to, my lord, the parliament to decide what sort of recognition is to be given, to what extent parity needs to be given. I have at page 58, if your lordship will turn to my, I have set out at least 10 aspects of recognition which will have to be born in, and only parliament can do it. Just look at page 58 if I'll just go back.
Mr. Dwivedi, again, what you are saying is not something which is lacking absolutely in substance.
I mean,
There is a germ of substance in what you say. But equally, there may be, it's a more nuanced or a layered argument. One is sort of a constitutional recognition of the components of an associational relationship short of marriage. Two, the administrative or civic incidents of that relationship. And three, legislative recognition. Legislative recognition, legislative regulation, legislative acceptance undoubtedly has to emanate from Parliament. No question about it. Two, the administrative or civic consequences of a relationship, which the Solicitor General said that we are, obviously the government has taken the first step forward by saying that the government is going to constitute a committee chaired by the Cabinet Secretary. Second, but even more fundamental, in some ways and not so fundamental because ultimately it has to see progress on the ground, which is how do you define and how do you give meaning to the content of constitutional values? Even assuming that we accept your submission on the legitimacy of marriage as a social institution, the stability of the order, the legitimate interest of the state in protecting the concept of marriage as a heterosexual relationship, or deciding to what extent you will also dilute that concept. It's a matter for the state's legitimate interest and parliament to regulate. Equally, there is, even in this area that we are debating, some element of constitutional jurisprudence left for the court to evolve.
Well, sir, with great respects, the court will not be issuing a declaration which is amorphous, vague. Some sort of recognition needs to be given. I mean, a declaration emanating from your lordships has to be concrete and definite, which results in something positive straight away in their favor. Else-
Is it that something, are we in a, are we in a society, a constitutional society? And we are now approaching our 75th anniversary. Are we in a state where we say that a declaration by the state, by one of the co-equal wings, which is tasked with interpreting the constitution? I am not
Yes.
saying exclusively because other wings also are entitled to. When it says that this is it, and beyond that it will not say, it cannot say because it cannot implement it.
And we are
Right.
conscious of the fact that we cannot tread into the legislative domain.
There are limits.
So
Surely.
once we say that, does it not have its own force? Are we trained?
Well,
Let me complete. Let me just complete.
Sorry.
Is common law seeped into our bones to this extent that everything that we say needs to be executed through contempt or through some execution proceeding? Is it not sufficient that the court says that this is the state of affairs? And that's out there for the people, for the parliament and other branches of governance, including constitutional branches of governance. And I'm not talking of only the constitutionally recognized branches of governance, the society at large, that this is the state of affairs. How it is assimilated is not up to us.
I'm certainly not saying that lordship's jurisdictions to make an
No,
appropriate
I'm taking
declaration
it-
is not there.
Yes,
That's not
I'm
my.
taking it beyond the writ of mandamus. I'm
But
just
what
taking it.
what I'm requesting and beseeching your lordships is that please do not issue a amorphous, vague, too general a declaration which has no meaning.
But take the case of privacy, right? We located privacy in constitutional precepts, but we were conscious of the fact that if we have to implement
So your lordship,
privacy in the concept of, say, informational privacy or data privacy, we can't do it ourselves. It has to have a legislative
But-
backing.
but
And
your
therefore, we left it to Parliament to
that-
legislate.
my lords, in that
But, Mr. Dwivedi, the very act of the court having granted a certain degree of legitimacy, constitutional legitimacy to privacy, has a very vital role to play in society.
No, but that was not a general exercise because your lordships had an Aadhaar Act in front.
No.
No.
When it came to
Informational-
the 9 judges, there was no such.
Aadhaar. It was
What
independent.
was
of Aadhaar.
argued, you
No,
are
the
aware.
judge's reference came from that only.
Correct,
No.
maybe, but then it was an abstract reference.
Because Mr. Rohatgi argued that there is no right to privacy.
The only question was privacy is there or not.
But then it's a wider concept now. There is no
That-
law.
Well,
Even today, there is no law.
9 judges' judgment did not involve any declaration for the purposes of Parliament to do
Very
something.
well. All right, I'll go back. What did 11 judges do? 11 judges did not have a statute before them. Now, Mr. Sibbal is there.
No, they did.
There is no statute which has been invalidated. There was no statutory model
No,
before the
it was
court.
a reference in a pending proceeding. With great
In
respect,
regard to
certain
what?
questions are
What is
every day referred.
So what is the
That is
content
quite
of 30?
different.
Mr. Dwivedi also argued. We all know that. It was only argued what is the content of 30. It's in the abstract.
No,
Why you're finding it difficult? What we are talking about, both Chief Justice and Justice Bud is talking about, if there is a right, it's a recognition of a right. The order of a court is in the context of recognizing the existence of a right. It's thereafter for the legislature. Court might not be able to do or take up any executive action to implementing it.
so
Once there is a recognition and court stops there, it is thereafter for the
so
executive
that's
to take it up.
precisely where I'm, my lord,
And it's
engaging
one of
in-
the most important and
No, I appreciate,
accepted
my lord,
function
but
of a
this
court
is
to give a
precisely where I'm
recognition.
engaging in this debate, my lord, is that when it comes to recognition of a right, then this is a sphere. What sort of recognition your lordships will be
Different.
providing?
Absolutely, you're right.
That's the.
Now, let me just state 10
That's
points, my lord.
exactly what we are also deliberating on.
matter.
We are sort of introspecting at this stage. We are now almost towards this last third of the arguments. That's why we sort
So
of,
in fact, that's. one of
we are
the
also in a
core
state of
functions the court.
mental
No, no, I appreciate.
churning.
It's important, my lord, for such debates to happen, and therefore, my lords, I'm requesting your lordship just to listen to this, my lords. Now, if your lordship wants to, sorry, my lordship.
No, please,
Go ahead.
please.
If your lordship is considering, hypothetically, I'm taking.
And Mr. Dwivedi, a lot of what we say to you is not only meant for you, it's also meant for the other side.
My lords, by now, my lords,
You are fully
at
aware.
the fag end of
You're-
our careers, my lord, we are aware of all this, my lords.
You're conscious of that as much as we are after long
Many a
experience at the
times.
bar.
That's
Yeah.
how it is.
That's how it is.
learning our lessons in it.
churning process.
Yeah, of
And
course,
I
my lord.
think in a way, all of us here are privileged to
In
go through
fact,
this exercise of the mind.
One important aspect of this proceedings is, you know, that there is churning in the society. People are,
Right.
because of this debate, there is,
Absolutely.
and because of the live streaming, so in different corners of the country, people are thinking about it.
There is
And
a-
there are, you know,
Mr. Dwivedi,
reactions.
so many which ways actually. The live streaming of court proceedings has really taken that our court absolutely
different
to the homes and to the hearts of common citizens. And I think that's part of the process. I
The
mean,
only thing is
obviously-
that our debate happens in English language, and in the villages, etc., people will not be able to follow, my lord. And the language problem in India is very complex. So,
You'll be surprised. We are working even on that, Mr. Dwivedi. Even
Yes.
that is not lost to the Supreme Court on its administrative side.
Live audio
We are
translation.
working on this. You see that transcript which you
Yeah.
have there?
it's being
We're
translated.
now trying to use technology to ensure that the live streaming content can be
Yes, immediately.
simultaneously made available in
That's
languages
great.
which the citizen
But
can
in
follow.
fact, technology now allows,
Of course.
if you are speaking in English,
Subtitle.
Speech to text.
simultaneously be heard in Japanese
Yes, correct.
without a translation.
We have it.
It's speech to text.
Mr. Sibal.
Mr. Sibal,
Mr.
it's
Sibal,
speech
it
to
is
text.
right.
Telugu,
Yeah, or speech to speech as well.
already.
Not only it's available,
Yes.
it's very much available.
And that's the beauty of it.
That's the beauty.
We must put it in.
Basically, Millers, we are in the midst of a tectonic shift in societal values. Where we recognize it, where we stop is the issue before the court.
Absolutely.
That's the issue.
So there are 10 aspects, my lord, which will arise.
Now, Mr. Dwivedi, as the
Page 58.
as the head of the family, I have to now hurry you along. We are in the thick of debate with you, but we need to now just hurry along so we get everybody else
So
a chance.
just let me just,
Yes, now just 10 points if you can formulate so that we can then
It's
take it up.
already
Yes,
there.
you have put
I
it
think
down.
that's what you're saying, D9, right?
Yeah.
page
So let's
58,
quickly look at it and then
page
we'll wrap up.
58.
Page 58. No?
D9, D9.
Yes.
Nine.
D9. So
Exclusion.
there are various aspects of recognition, my lord, and therefore I'm submitting, my lord, that this has to be left to Parliament, my lord. It can be debated there only in the legislatures. So many aspects are required. And unless all of these enter into your lordship's consideration and some declaration comes, my lord, which measures all these.
Let's see D9.
The claim for recognition gives rise to several questions. That is, what sort of recognition needs to be given? What form of recognition should be given? Should the recognition be given by inclusion in an existing law or means of a separate law? Should the recognition be given at par with heterosexual marriages? To what extent parity needs to be given? Should parity be given at one go or in phases? What should be the spacing of phases? What will be the repercussion of granting par with either heterosexual marriages or transgenders? Determination of whether a majority of same-sex relations and transgenders desire particular recognition with all consequences. Whether the society is sufficiently ready to accept the particular kind of recognition to be given.
Thanks, Mr. Dwivedi. Can we now wrap up, Mr.
Now-
Dwivedi? I think you've made your point on this.
Now, my lords, on 21, my lord, Mr. Rohtegi said,
Where is your 21 argument, Mr. So we can just quickly run through that.
B10.
well, just a word about Article 14, where I was, when this lordships put questions to me. And that is, my lord, that
Mr. Dwivedi, why don't you do this? You're right, we interrupted you. In 2 minutes, you can now wrap up your Article 14 arguments. We have the overall perspective so that you can just
I'll
sort of put
quickly
it
just
together
formulate
and
each one of them, my lords.
Page 32, Chief.
On Article 4. Drawn attention to two aspects, in addition to what has already been submitted by the learned Solicitor General. The first is, my lord, that when this Act, Special Marriage Act was made in 1954 and the other codifications, at that time, there could be no discrimination at all because of existence of 377, which came to be struck down much later. So at that time, when the parliament was confining itself to making certain regulatory measures, codifications with respect to heterosexual marriages alone, there could be no contention raised that at that juncture, my lord, it was, the only question will be, my lord, what has happened subsequently is only navtage which has decriminalized, which comes, my lord, now, 4 years back. Is the consequence of this change such that these laws or any of them become discriminatory and violative of Article 14 now? There are cases where Lordship said that a law may be good when made, but subsequently some supervening change may have happened, my lord, which may result in its becoming discriminatory. So it cannot be, my lord, this law immediately on a declaration in navtage results in these legislations or some of them becoming discriminatory and therefore requiring, my lord, whether it should be altered or not. Because the question of alteration arises only if this has become discriminatory. The second aspect which I wish to submit is that in view of the core idea of marriage which I have submitted before your lordships, in view of the immense continuity, my lord, the enormous continuity of these customs, etc., even today, it cannot be said that this has become discriminatory because these laws have not been amended to accommodate them. So the question of knocking down this does not arise. Particularly keeping in mind, my lord, that Parliament is fully entitled not to make a comprehensive legislation. After decriminalization, there has to be a process. How long it will be or not, one doesn't know. It is for the Parliament to assess and decide when to come out with what law. It cannot be said that now this judgment, navtage has come, so within 4 years have passed, nothing has been done, and so now make insertions, amendments. Now at page 42, my lord, is Article 15. My respectful submission is, my lord, that 15.1 doesn't have any impact because most of the regulatory laws and the substance of them is to provide protection to women and children. And it is protected, therefore, by Article 15(3). That's one. The second is, my lord, at page 43, in Indra Sahni's judgment, the majority view emphasizing the presence of the word only. I have extracted that portion at page 43. Your Lordship will have the last 4 lines. When in such circumstances, provision is made for reservations, for example, on the basis of caste. It is not a reservation in favor of the caste as caste, but in favor of a class or social group which has been discriminated against. And discrimination cannot be eliminated otherwise. What the Constitution forbids is discrimination within quote only on the basis of caste, race, etc. However, when the caste also happens to be a social group which is backward or socially and educationally backward or a weaker section, the discriminatory treatment in its favor is not only on the basis of caste. So therefore, the word
That goes as far as it goes. In that
Yes.
context, it's 100% right. But there can be other shades to this only. Supposing you're while employing someone, you say you belong to, let's say, Uttarakhand, and therefore I'll not employ you. And say you also there are other factors.
all I'm saying is that the word only therefore has to be established. If it is only on the ground of region
No,
or
no, I'm
religion or
putting it
something.
the other way, Mr. Trivedi. This only has to mean something else, in my opinion. Of course, I'm speaking against the grain because Nargesh Mirza and other previous judges. Only cannot mean that these proscribed ground can also be there plus others. Can you say while employing? I'm not talking of reservation. That somebody
No,
is
so
an ST or an
it
ST.
cannot be any plus plus.
Ah,
Any insignificant
It-
plus plus. That
anything
my Lord
else
Justice
for plus.
Chandrachud
I
has
said
said
that in Navtej.
in Navtej, Your Lordship
Also
has
the
said.
army
Only
women's
is only by
matter.
way of
Yes.
emphasis.
So I'm not meaning that. Then any insignificant plus plus
So
something. and therefore-
discrimination otherwise on the ground of gender will be valid,
But
so long as it is a discrimination on gender and some other
Bracket-
attributes.
bracket it
That's
with
not,
other
that's not how you
but
interpret Article 15.
but if the other attribute is a major one, which is also being factored, then yes, it will have a play, my lord. That's what I'm submitting. That's what follows from.
Then
And
this
our
be-
theory has gone far
Ah,
beyond, Mr. Dwivedi. Now we have
correct.
spoken about
Indirect.
intersectional
Indirect.
discrimination.
Even so, my lords, we can't ignore the terminology which has been deployed there of only, my lords. It can't be ignored. Yes. As far as I'm concerned, I will
Then
say
you
that
see,
any
then it becomes
insignificant or
very
minor
difficult.
plus plus will not
You
be
have
the
to give
difference.
that content.
Correct.
But
The
here-
word only has to be given a content,
Content,
which is
that's
more
all.
compatible with the
Otherwise-
Constitution as we see
But
it
here
today
the-
evolve.
But here, proceeding further, my lord, the question is, we are taking note of one sexual orientation. Moving forward, my lord, one sexual orientation which is resulting in the same-sex relationship. But there is the other sexual orientation which is involved in the heterosexual marriages, which I have already elaborated. My lord. It's not that that is not a sexual orientation. That is also a sexual orientation, particularly when the women are being protected and is squarely following under 15(3). So that sexual orientation is of coming together for the purposes for a good of the society. The procreative good is a good of the society itself.
That point you have made, Mr.
So, but that's also a sexual orientation.
All right, thank you, Mr.
Now-
Vidi. I think we can now go on to Mr. Civil. I think we've given.
Just
adequate
one,
time.
my lord, if I may just submit a paper, my lord, about why, my lords. There's a 2 pages which I have given to your lordships.
Today?
Yes.
Is it part of the?
नहीं, ठीक है, दे दो. Just have your junior email it also so that it becomes a
I
part
think it
of
has
the-
been emailed.
No,
but Lord Justice
just email it to the court master. So it'll become a part of our electronic file.
Thank you.
Other side goes.
So Dwivedi, this you have already stressed actually. You have spoken about why Kennedy and Sachs are wrong and why you don't accept Mata Nausbaum's writing. We'll have a look at it, Mr.
Your
Devi.
Lordship, may I have a look?
Yes.
I'm grateful, my lord.
Thank you very much, Mr. Devi. Yes, Mr. Sibal.
Won't take too long, my lords. Lordship has already, my lords, gone through all the law.
Does he have a written?
Well, I
don't know.
I've sent my propositions, my lords. They're already hopefully before your lordships.
Yeah.
Under what head? What head?
We also have printed.
No,
have
Mr. We don't
there
have
is
that.
no-
have any of
If you can have some, your junior,
We've
email it to
circulated.
the court master, we'll immediately get it.
We have circulated it, my lords, but
No,
we'll give you the
no.
print.
Nothing. Not on the,
It's been,
Just then. Oh.
just sent.
I've got physical copies
No,
also.
let's do it on the electronic form,
Yeah.
all of us.
All right. Give it to them.
Mr. Sibal, what happened to your iPad?
I have it. Well, lords, I have it and I'm going to honor, my lords, my commitment to your lordship.
We had to do,
In this field at least, my lords.
to do it in other codes too, besides
So
code
it's a
one.
temporary measure.
Is it a proverbial elephant's, dust?
No, my lords. In fact, I have been assiduously, my lords, trying to learn on a daily basis, my lords, and I've managed, my lords, quite well. My lords, I'll start off by saying, my lords, that I was very worried, my lords, at the outset of the hearing, when on the other side it was said that Parliament is not going to do anything about it. We don't expect Parliament to recognize this particular right. And therefore, we urge your lordships to give us a declaration. Because I'm afraid that that's a very dangerous proposition.
Sorry, will you repeat yourself, Mr. Sibal?
I'm sorry.
Will you repeat yourself?
Well, it was said, Malad, at the outset that we don't expect Parliament to move forward. We don't expect Parliament to pass such a law. And therefore, your lordship should do it. And I said, Malad, that's a very dangerous route to take. Any law of this nature, Malad, which is pursuant to a tectonic shift, as I said, Malad, in societal values, requires public discourse, which includes discourse in Parliament, it includes discourse outside Parliament, within the assemblies, outside society. And therefore, Malad, a declaration by itself on the premise that Parliament is not likely to pass a law, Malad, is, as I said, a wrong step forward. But Malad, let me go to the heart of the matter. When your lordships were dealing with Nalsa, you got it?
What's happening in 40?
16.
18.
It's a dangerous route to take, Malads, because a declaration by your lordships will close the debate in Parliament. There will be no scope of debate once you declare. One, that it's a fundamental right. Two, it has to be recognized. That's, Malads, with the greatest respect, Malads, something that your lordship should be cautious about. Nothing more than that.
Parliament can overrule a declaration also, no?
Sorry?
Parliament can overrule a declaration.
No, no, but your lordship knows that once your lordships have declared, Parliament cannot overrule it. I hope, Mullah, that stage has not come for Parliament to overrule what your lordships decide. I'll be on the other side when that happens, Mullah. But Mullah, let's Mullah, go to the heart of the matter. In Nalsa, your lordships decided sexual identity. Sorry. In Nalsa, Mullah, your lordships decided,
Nalsa, you say.
yes, sexual identity, nothing more than that, of transgenders. In the privacy judgment, your lordships decided upon the contours of privacy, both in the private space and the public space.
Can you say that again? Nalsa was a declaration.
Yes,
Identity.
there was a declaration.
Identity.
Yes, exactly. On sexual identity. That's right. In privacy, you decided on the space for privacy, both the private space and the public space. That even the public privacy must be protected. In Navtej, you decided on decriminalization.
So conceptually, you say the third one is slightly different
Yes,
because it is only a decriminalization which is statutory.
correct. What you are today deciding are two things: sexual unions and recognition by the state of sexual unions. That's the issue, Malaj. None of these issues, Malaj, were looked upon, decided, contemplated, thought through in either of the three judgments. So any Malaj reference is made in the context of those three particular issues decided in those three can't Malaj be taken as concepts which must be a fortiori accepted by your lordships. Right? So first you have to decide, are they a separate sexual identity? And in the ultimate analysis, Malaj, my answer will be yes. Next step, should they be recognized by the state? The answer is not through a declaration. This broadly, Malaj, is going to be my submission before your lordships. And Malaj, I respectfully, Malaj.
Just a little clarification. Your first question was, are they a separate sexual identity? And you said yes.
Yes.
Second, should they be recognized by the state? And your answer was not through a declaration.
No, their sexual identity, yes.
Yes.
right? Once your lordship recognizes it, then the question arises, sexual identity as a sexual union.
No, I just had a little clarification because, I'm just
Yes.
taking the submission down. Second point was, should they be recognized by the state?
Yes,
To which you said not through a declaration.
not through a declaration.
Now, when you say should
Not
they,
through a legislation, I said.
not through,
A legislation. No,
No,
they can only be done through a
yes,
legislation.
yes, that's right. I took it down.
So
like
you're,
that.
you're basically, you're advocating a Scalia-Roberts approach.
Yes,
Right. Now,
Absolutely.
when you said, Mr. Sibal, when you said should they be recognized, that's what my question.
that sexual identity,
The sexual
which is
union.
separate from sexual union.
Sexual union.
Union.
Not sexual identity.
No, identity, Malad, I want your lordships to give that declaration.
So that sexual, that word they, we'll just modulate it. to
Yes.
The sexual union.
Union, yes. Now, the question then arises, is this sexual union a marriage? That's what we've been debating, Malad, for the last an hour or so.
It was the third?
Is this sexual union akin to a marriage? If it is akin to a marriage, is it founded in any provision of the Constitution? Next question. And the third, for it to result in certain rights, it can only be done through recognition by the state, through legislation. There can't be a declaration to that effect. Well, as when your lordships ask the question.
Constitutional perspective, the constitutional lexicon,
Yes,
when you say can't,
yes,
the can't has to also fit into some constitutionally recognized prohibition.
yes. Which
You
is,
would say
Malad, that
that-
it's a regulatory exercise of rights ultimately have to be regulated.
No, that-
Regulation can only be done through law.
No, that's right.
Yes,
That's part of regulation. We are on a more fundamental path.
yes,
Declaration.
yes,
Well, we have now evolved to the extent of understanding what are constitutionally manageable standards,
yes.
existence of it, non-existence of it, matters which are not to be gone into the court by the court, etc. Where would you locate that? When you say a prohibition is prohibited,
Malad, I tell
declaration
you,
is
moment your lordships decide that this union is a marriage, in what context will you decide that, Malad? Ultimately, what is a marriage? The marriage is only a union.
Forget the issue of whether the court should declare this to be a marriage.
Yes,
We are now on the core issue as whether the court can issue a declaration.
that it's a marriage.
No,
that it's a union.
That the court can issue a declaration.
A declaration qua what, Malad? That it's a sexual union. That's all, Malad. It can't be doing anything
Yes,
more
you're
than that.
right. See, there is no declaration in vacuo or vacuum.
No, Malad, there can be,
Of
Malad.
course, you're right, but see that the court has in its repertoire a right to declare right from 1960, Justice Subbarao, I think that Kochuni onwards, which
Yes.
is there. Question is, what is that declaration we have to issue? Will it be marriage or not marriage or something?
That's the question that, Malad, I'll try and address your lordships on, but that's the really core issue.
So the court has in the past issued declarations, for instance, declarations which postulate that the implementation of the declaration requires legislation being enacted by Parliament.
Yes,
The right to a clean environment, for instance.
yes,
The implementation is ultimately for Parliament to
Health.
say health, education, which eventually the right to primary education found expression the Right to Education Act.
yes,
Or
absolutely.
the
Became
right
a
to
constitutional
food,
right thanks to a certain declaration.
or the
I
right
agree
to
entirely.
food, which eventually resulted in the enactment of a legislation.
I'm with you on that, Malad.
Therefore, at its core, as a constitutional precept, to say that the court cannot issue a declaration would not be correct. Equally, we take your point that don't go into an area where you declare a right to marry,
That's-
because that's Mr.
That
Dwivedi
was
has
the
argued,
intent. That was the
solicitor
intent.
has
That
argued.
was the intent. Malad, let's first of all define what marriage is before we move forward. And Malad, my
Yes,
Lord
we'd like
Justice
Mr.
Bhatt, your
Anil's
lordships,
assistance
Malad,
on that.
let's look into that. Ultimately, what is marriage? Forget about the law, 1955 Act. Forget all that. Marriage ultimately is a union. It's a union of two persons. It's a sociological phenomenon which deals thus far with heterosexuality. Thus far. It's a union, Mullahs. Even if the 1955 Act were not there, Mullahs, it's recognized within and without as marriage. When I say within, by two people, by that union, and without by society. So there are two elements to it. Recognition within, recognition without.
Could you just elaborate on that a little bit?
Well, for example, I mean, as I said, in the absence of a law, this union of two people with all the sacramental vows is accepted by a large majority of society for thousands of years.
That's the recognition without.
Yes, that's the recognition without, right? And that's essential. That's essential.
So the recognition without, according to you, then is the social recognition.
Is the social recognition. Thus far, it applied to only heterosexual couples. But it's still a marriage. But a marriage which is gained acceptability over centuries. The union between sexual union between sexually people who are homosexuals or whatever is still a union. You can't say it's not a union. They have a sexual identity which is separate. It's involuntary.
Involuntary?
In the sense, well, it's involuntary in the sense that these are their sexual.
It's not a matter of choice.
Yes.
That's what they call as ascriptive.
Yes.
See, in that
They have no
sense,
choice in the matter. That's how it is physically.
it could be said of both in that sense.
Sorry.
Could be said of both sets.
Yes, of course.
But that apart, it is voluntary in the sense that they choose.
Of course. I don't mean.
Just like in this.
The manifestation is involuntary. Otherwise, it's of course a voluntary union. I don't mean that, Melissa. It's consensual. It's voluntary.
Your sexual orientation may not necessarily lead you to a union.
That's right. It may not. It may not. That's what I'm saying, Melissa. Therefore, we are not talking about sexual orientation here, which is what I was started with. We're talking about a sexual union. And we are trying to give that a name. That's what we're trying to do, Melissa. That's why you'll ask the question, what's a marriage? Right? You give it a name. Now, they may consider that this is my marriage. Who can stop anybody? How can anybody stop them from considering that this is a marriage? Nobody can stop them. There are two people who decide that they want to live together. They live together for 10 years, 15 years. They say, I'm married to him. The moment you say now, without, you must recognize it, comes the problem. You may find it in 21, you may find it in 14, you may find it anywhere else. You may not find it in the Constitution at all. According to me, it's part of your right to be and to live as you please without interference from the outside world. It's part of privacy.
And according to you, the recognition without, if the court were to be invited to give a declaration of recognition without,
yes,
that would amount to an imposition on others.
That's the point. That's the point. That's the core issue before your Lordship. That's really the core issue.
If I could just translate it in a very colorfully, maybe not so. It's like drawing a blank.
Yeah.
It's like firing a blank. So which means that you allow it, but outside, the without, there is no acceptance, there is no.
That's really the heart of the problem.
The counterpoint to that is there may or may not be, but that lends us dignity in our own eyes. That lends us acceptance among our society.
Yes.
And the society without, to that extent, limited extent, among our parents, among those people who are willing to accept us. That is a point you may have to deal with.
True, Malad. That's certainly an issue that your lordships will have to consider. But the point that I'm making is, Malad, at the moment, what are they asking? They say under the Special Marriage Act, the rights given to heterosexual couples should be given to us. That's what they're asking. That's their ask, Malad. Nothing short of that. And that's what your lordships is considering.
Mr. Sibal, when we opened the discourse, we confined it, of course, we confined them to the Special Marriage Act with the idea in which we still maintain that we are excluding the whole gamut of personal law from the debate.
Yes.
But we're not really confined only to the contours of the Special Marriage Act in deciding the broader constitution.
That I know. 14, I'm going to come to that, Malad. That's the other issue. Is it discrimination?
So when we locate the nature of marriage, the institution of the marriage, we're not really then confined only to the Special
I agree,
Marriage
Malad.
Act or its
Therefore,
statutory contours.
I agree entirely. Therefore, your lordships are also considering whether there's discrimination under 14 or not. And therefore, can you then say that this is discriminatory? But where does it go from there? That's the next question. If you find it discriminatory, where do you go from there? That's an even more difficult task, Malad. First, to find that it's discriminatory, that itself is an issue, Malad. Because we are talking about separate sexual identities and unions.
We'll continue.
Yeah, we'll continue.
Mr. Sibal, roughly how long will you take just to have a...
I won't take much time, Malad. I'm not going to trouble your lordship with all the judgments. I'm just taking the dialogue forward, Malad, so that your lordship knows.
Because now we've seen the judgments. We like some assistance at the intellectual level now, and we just forget the judgments unless there's something somebody else.
That's correct. That's what I'll do.
After Mr. Sibal, who will be taking over? Mr. Datar will be, and after Mr.
Yes, after
Datar,
me,
Mr.
Mr.
Jay Sai Deepak. So Aishwarya will be arguing. All right. Then
just about half an hour, not more than.
so we've Mr. Datar, Ms. Bhatti, Mr. Ms. Manisha Lavkumar, and then Mr. Jay Sai Deepak. So we would tentatively, this is not the sort of a bench which wields a guillotine, but tentatively we'll keep it for lunch tomorrow for this side.
I think so.
So that then the other side will
Yes.
conclude their rejoinder by tomorrow afternoon.
That's fine. It's deeply obliged.
Mr. Solicitor, do you want to? Mr. Solicitor, Justice Bhatt has a very good idea. Mr. Solicitor, you emphasize the general part of your designation and ration the time between your team now.
That's already been done.
That's it.
All right.
That's it.